Hello again. Okay, for week 2, we have some shorter videos this time because there's less course material, so don't be alarmed when you see fewer of them or shorter ones. I'm also trying to keep each one under 10 minutes because the video camera records about 10 to 12 minutes and then it will stop the file and start a new file, so we'll get some technical issues there. But I'm splitting this up a little bit differently. The first 1 or 2 videos, depends on how long it takes, are going to be basic concepts. Then I'll upload those first, and then we'll go do a second video on the individual cases, and there's only maybe 5 or 6 this week. So I can probably do that one in 1 to 2 videos as well. So look for those. And that means you should definitely watch the layman's terms video, the first one that will be posted. But if you have a good handle on the cases, you may not need to watch all of the other one. It's just specifically to show you what the cases that we're talking about this week are about. And they just, remember, illustrate the topics that we're going to talk about in this lecture today. Okay, so we're going to start with marriage. How do you enter into the contract of marriage? Remember, it's a civil contract. We'll talk about the consequences in a second. How do you enter into it? You can't just go willy-nilly and decide to get married to whomever, whenever, whatever, all right? The first step is that there are formalities required. And so typically, you will need a license, you'll have to have some sort of ceremony, and the officiant is going to file the license after the ceremony occurs. And who can be an officiant in some states differs. There are some states where any lawyer can be an officiant. I think in Kentucky it's just judges. I can look that up for you, but I'm actually ordained to marry people in Kentucky, which is the only reason I know this. And it required me to be an ordained minister. My law license was not enough, but that's also because it was an Indiana law license. But I looked online and took... literally signed up for a website that allowed me to be an ordained minister, and if I get that ordination and I take a copy of it to the circuit court, I can marry someone. And I know this because had COVID not hit, I would have, but my best friend's wedding has been postponed ad infinitum now because of the virus. So those are the formalities: a license, and sometimes there's a time frame, and so some requirements that are going out of style. Blood testing. I'm sure there's some jurisdiction somewhere that requires it, but it used to be that you had to have a blood test before you could get a license so that they could make sure you were communicable disease free, because no one historically would ever have sex and presumably spread a disease without being married. And that was enshrined in the law. It's going away. There are some time frames. For instance, you may have a license. If you get a license, you might have to get married within 60 days of getting that license. And then in the application for the license, you have to say things like what your full name is, where you live, your age, sometimes who your parents are. So that's really it. But those specific license requirements are going to vary a little bit from state to state, but it's nothing out of the ordinary. You do not have to live in the state you're getting married in. And it's pretty straightforward. This ceremony can be by an ordained minister. It can be by someone like me who just signed up for an ordination and paid. I don't even think I paid for it. I think it was like $40 for the certificate. And I didn't even get that yet. Or it can be a magistrate, a judge, someone who's civilly qualified under your state's law, whatever that is. And then once the ceremony occurs, it often needs to be witnessed, and so those witnesses will sign on the license as well, and then the officiant will file that. This is another example of, if it didn't happen on paper, it didn't happen. This is what gets you that civil contract to marry. So that's number one. We've got these formalities that have to occur. Number 2. You have to have the mental capacity to marry. You might remember from contracts, the mental capacity to contract is pretty low. You have to basically understand what's going on. The mental capacity for contracting, for being a juror or a witness, is fairly low. We don't require IQ tests or reading tests or anything like that, but you do have to have some sort of mental capacity. You have to understand what you're getting into. You have to understand the rights of marriage, and you have to understand the duties of marriage. But that's a fairly low standard. Once we get to the case video, there's a case that illustrates that fairly low standard. Number 3. The relationship between the parties matters. If you are closely related by blood, and so we're talking about the familial relationship. That blood relationship, that family relationship, cannot be too close. And usually it's statutory. Your statutory will tell you the width of that relationship, how far it has to be away. If you have a common ancestor, in some states, first cousins can marry, in some states they can't. It just depends on where you are, but that relationship, that blood relationship between the two of you cannot be too close. Again, this is a throwback to children, because marriage typically predated children. We don't necessarily have that anymore, but this was a desire to keep genetic abnormalities from happening in close relationships of sanguinity. Another case will illustrate that as well. Then we've got age. Here's where we get to a little subsection, the subsection that you read on void and voidable marriage. So there's going to be a statutory limit, a statutory minimum. Not limit. There's no high end to it. There's just a low end. If you take wills, trusts, and estates, you might read about Anna Nicole Smith, who was 26, I think, when she married someone in his 70s or 80s, who then did not live very long. But there's no upper end to it. As long as that mental capacity is there at some point, could an elderly person be mentally incapable of marriage? Absolutely, but it isn't based on their age. Okay, so there's a statutory minimum. Sometimes that's 18, sometimes it's 16, sometimes it's 16 with parental consent. This statutory minimum is something that's changing because people are more aware of child marriages, and just recently there was a state that, it might even have been Kentucky now that I'm thinking about it, that was looking at increasing the statutory minimum age because as recently as last year, there were many states in the country that allowed young people to get married, sometimes even without parental consent. In addition, historically, some of these statutory minimums were lowered if the wife-to-be was pregnant. So it might have been, for instance, 18 if she's not, but if she's pregnant and she's 16, we're going to let her get married. That's widely changing. It isn't even something that we could look at it today and it could change pretty quickly, because this is sort of a social justice piece that people are really working on changing and getting marriage to be 18 across the country. That being said, this is a nice segue into, and I'm going to change colors for this, what you read first, and that's void and voidable marriages. So keep that in the back of your head, because it's going to apply to 4, age, and it's also going to apply to 5. The last formal qualification we have for marriage is that you can only be married to one person at a time. Is this something that may change? I think so. The more polyamory becomes widely accepted, and the more that we change what the definition of a family is, I think we've got a good chance that this is going to change. But now you can only be married to one person at a time. So age 16 to 18 and up, depending on your state, and one at a time, or no bigamous marriages. So keep these in the back of your head as we go into the discussion of void versus voidable. A void marriage never existed. It was bad from the start. It was usually bigamous from the start. So in a bigamous marriage, that means the person that you married was already married to someone else and did not get divorced before they married you. A void marriage is illegal from the start. It doesn't exist. You are not married to this person because they are already married to someone else. So in this situation, remember how you get married. You get a license, you have a ceremony, you sign it. Are there any checks to see, legally speaking, if any marriage certificate has been filed without a divorce certificate? No, that doesn't happen. So it's entirely possible that someone could get married after already having been married and that you wouldn't necessarily know it. If that happens, the second marriage is the bigamous marriage, and there are multiple consequences. One is that second marriage is not actually a marriage. But does the marriage certificate exist? Yes, it doesn't just automatically poof. The property you acquired together just not automatically just go away or revert to someone's single name. It doesn't work that way. So this is where we get the concept of annulment. Now, you'll hear in plenty of other contexts, you'll hear little phrases about the law that may or may not be correct. Possession is 9/10 of the law. It's a bad one. I repeat these things so often, I may have said that in your earlier video, but possession is not 9/10 of the law. It's just not the case. But another one is, well, if I don't get along with him, I'm just going to get it annulled. No, you will not. Annulment is rare, and we'll talk about it more when we talk about divorce, but a lot of people have the notion that, well, if we were married less than 30 days, I can just get it annulled. If we never consummated the marriage, if we never had sex while married, I can just get it annulled. Generally speaking, no. Annulment is this process where either with a void or voidable marriage, an annulment is going to be a court decision that says you were never married. And so if you've got someone who's been victimized by a bigamist, and that second marriage is going to impact this person because there's a marriage certificate out there that says they're married. They may have credit cards or houses together jointly. They need a court determination so that other people can know they're not actually married. They can't get divorced because they weren't married to begin with. But an annulment action can give them the judgment that they were never married once proof of the bigamy is established. Bigamy is also criminal. As a prosecutor, I had one bigamy case because they're pretty rare, and it was the weirdest case ever because it all the jurisdictions that it could have been filed in basically said it's not. It doesn't happen very often, so people don't know what to do with it. Every jurisdiction that could have been filed in, the judges were like, no, this is the wrong one. And so I had to tell the victim, I'm like, I took it to court. The judge dismissed it because they didn't think our jurisdiction had jurisdiction. And the victim's like, what am I supposed to do? I said, well, you can go to civil court to get this annulment judgment. But I couldn't prosecute the guy because the criminal court said I can't remember. I think the parties were living in my jurisdiction at the time, and the court said that's not where the bigamy occurred. The bigamy occurred where the marriage took place. So she had to start over, and I don't remember what happened, but we struggle with issues like these. Okay. Let's contrast that with avoidable marriage. Avoidable marriage is one that you can get out of. Now, remember, contract principles are going to apply, just like they have in a couple of other instances so far. Avoidable marriage you can get out of. When can you get out of a contract? When is a contract voidable? When someone is under 18 and they sign it. There's a reason that when you buy a car, or when you get your ears pierced, when you do stuff that's sort of consequential financially as a minor, that your parent has to sign off on it, it's because you can get out of it. We have that same concept for voidable marriage. So if someone gets married under the age of 18, because some statutes will allow it with or without parental consent, depending on the state, they can get out of that marriage and void it with an annulment before they turn 18. It only applies to the party who's under 18. So if a 16-year-old marries a 19-year-old, the 16-year-old can void the marriage, the 19-year-old cannot. When they turn 18, if they stay married that entire time, now the marriage is no longer voidable, and they cannot use an annulment to get out of it. They have to get divorced. So the voidable marriage doesn't last forever. It only applies to the party who is under 18, and it can be rescinded just like other contracts because a minor entered into them. And once they turn 18, then there's the stamp of approval on the marriage, and divorce is the only way out at that point. So that concludes how you get married with the formalities of it, and the 5 different things that matter: the formalities, the mental capacity, the age, the one at a time, and the relationship. You can't be closely blood related. Okay. Since that's a nice solid chunk of material, that's where this particular video will stop, and I'll pick up with another in just a minute.